What's up, everybody? We are here today to talk more Kohberger. I also recorded a Corey Richins video today for a little update on a civil lawsuit that has been filed that's going to drop, I believe, later tonight or tomorrow morning. So hit that subscribe button and reminder bell so you don't miss any of the action coming your way. Yes, I think this is the first video I've recorded live since we hit 250,000 subscribers. So thank you all so much for that. That's fun. Every milestone is a surprise and is just so much fun. And I appreciate everybody that's a part of it. All of you guys are such a huge part of it. And I just, this format is something that it's like you never knew you needed, the thing you never knew you needed, but I need it now. And it's such a great thing to be able to talk about these issues, learn from each other, look at how laws are applied across the nation, different states handling things different ways. We're going to run into that today talking Kohberger because the main focus of the video is going to be on these quote unquote prior crimes, arrests, whatever, the report of his prior theft, which could be considered a crime of moral turpitude, which could be something that could be impeachable if he takes the stand, and all these things that we're going to discuss at the later part of the video after we go through a couple documents, just 2 documents. So it's not going to take us long to get there. This is not a long tease. The whole thing is Kohberger. The whole thing is us talking about what's new and the update on this case and answering your questions, of course. I am going to start that section by reading an article from a huge news organization, and then we're going to break it down in what reality actually is, and why it's coming out the way that it's coming out. Thank you, Cheryl, for the congratulations on 250K. I appreciate it so much. And John, thank you so much as well for coming in to celebrate. And Amber Nelson, yes, don't forget to hit that like button. Hit that like button now so we don't have to worry about it later. I'll remind you at the end just in case you forget. So let's look at first this order from the judge clarifying the meaning of agents. And I couldn't remember if I did this or not. I guess I didn't, but the meaning of agents within the gag order. And the first thing I want to say about this, the fact that there is a clarification, that there is clarity, that there is already an edit to the gag order or the non-dissemination order that the judge just put in place, is this judge does not have an ego problem. His ego is not his amigo, or whatever Mark Eiglar said. He sees an issue. Somebody asks about an issue. They're confused about something in the non-dissemination order. Instead of ignoring it and making them file all these motions and set another hearing, he clarifies it himself and edits, makes the edit appropriate so everybody knows what's going on. This is Judge doing a good job judging. And I appreciate that. If there's an issue, fix it if you can, especially if it's not that big of a deal, which in this case it's not. On June 23rd, the court issued a revised amended non-dissemination order. Accompanying the revised order were 2 lengthy opinions. In this court's view, those opinions made clear. So the judge said, I think I made clear that agents of the attorneys involved in the case, including law enforcement, could have and would have their speech regulated under the revised amended non-dissemination order. However, following the issuance of those decisions, the decision with the media and Shannon Gray, and the revised order, the court took judicial notice of some news articles stating that law enforcement were not or no longer bound by the revised order. So the judge is like, hey, I thought it was clear. I was wrong based on media reports and the way some people were talking about it. So here we go. In an effort to clarify that misunderstanding, this court issues the following guidance. The revised order applies to prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family. These individuals are not completely barred from speaking about the case, but must adhere to the restrictions on their speech imposed by the revised order. Agent, this is what he's adding, agent is defined as someone who is authorized to act for or in place of another, a representative. That's according to Black's Law Dictionary. Agents of the prosecuting attorneys include law enforcement working on this case, or even if they haven't worked on the case, if they're privy to confidential information involving the case. Similarly, investigators hired by the defense are agents of the defense. This is because those individuals are working at the direction of the attorneys to investigate the case, interview witnesses, and gather evidence. Stated differently, law enforcement and defense investigators are acting as representatives of the attorneys. The attorneys have the authority to direct certain actions of those individuals when it comes to building their case for trial. Other agents include staff in the prosecutors and defense attorneys' offices and expert witnesses. This order does not change anything in the revised order, but merely helps to further clarify who the revised order applies to. Now, you may think this is no big deal, but I will tell you, there are absolutely some judges who would say, figure it out and you better not be wrong, or else you'd be violating a court order. But instead, this judge says, you know what? I felt like I was very, very clear, but because you didn't, I'll come in, I'll help clarify, I'll try to make this easier on you. And there we go. Bada bing, bada bang. No more issues. No more problems. Everybody should be on the same page now, right? The next document we're going to look at is the order on the defendant's motion to compel discovery. On May 4th, the defendant filed a motion to compel discovery stemming from defendant's second supplemental request. They heard oral argument. They heard arguments from the state, from the public defender. At the outset of the hearing, the parties informed the court they had reached agreements on some of the issues, but not all of them. Idaho Criminal Rule 16b-4 states that papers and documents that are material to the preparation of the defense that are in the possession, custody, or control of the prosecuting attorney are discoverable. Additionally, Rule 16b-10 allows the court to order material and information be made available to a defendant where the defendant shows, it's important, they have to show a substantial need in the preparation of the defendant's case for additional material information not otherwise covered by Rule 16 that the defendant is unable to, without hardship, to obtain substantially equivalent material by other means. So, if the defense could have just gotten this themselves, the judge would not have ordered it. However, if they can't and they need the state to produce it, the court can order the state to produce it. During oral argument, the defense argued that it needs the training records of the three specific officers identified in their request to understand the processes and methods the officers utilized. Specifically, the defense wants to see what training these officers have received in interviewing witnesses and collecting and evaluating evidence. So the defense specifically spoke about why they need this information on these specific officers. The defense argued that the three officers identified each played a critical role in the investigation of this case. One officer interviewed witnesses at the scene of the crime and worked on the search for a specific car of interest. The second officer interviewed key witnesses expected to testify at trial. The defense expects to subpoena this officer for trial as well. Finally, the third officer conducted multiple interviews of key witnesses after Kohberger was arrested, attended the victims' autopsies, and made decisions about what tips provided to law enforcement warranted further investigation. All incredibly important stuff to the prosecution's case, but also to the defense. The state argued that the three officers identified are not material to the state's case, which is a very weird argument, and will not be called at trial. Further, the state argued that the defense had shown a substantial need for the information requested, that they had not shown a substantial need. In State v. Kohberger, the Idaho Supreme Court, in applying the attenuation doctrine, discussed how the training of law enforcement officers receive regarding the law of search and seizure should play a role in evaluating the flagrancy of their behavior. Similarly, courts have required the government to disclose relevant canine training and certification records to allow defendants to assess the canine's reliability and effectively cross-examine the dog's handler. By way of this court's own experience, when testifying at pretrial hearings or at trial, officers often base their testimony on their training and experience. Hey, chat, how often do we hear officers say, I'm basing this off my training and experience? How often do we hear officers give their opinion, state more than just the facts? Because they are trained and they have experience. Here, the three officers' training records requested by the defense are material to the preparation of the defense. And Kohberger has established a substantial need for the material in preparation of his case. First, the defense adequately articulated the role each of these officers played in interviewing witnesses and finding and collecting potential evidence. Second, the training records of these officers are potentially relevant to a suppression issue, like in Kogan, or to challenge the credibility of the officers and the reliability of their methods, similar to the training records of canine officers. Other potential uses for the training records include help to prepare the defense for for examination or cross-examination of the officers at trial, or to help establish a challenge a foundation for the admissibility of evidence gathered by those officers at the trial. So what's important about this is that the court is leaving the door open, in my opinion, that they might get more records in the future. There may be more officers that are material and their training records important and discoverable, but not saying that all of them are. You're not going to get all the training records from every officer that touched this case or knows something about this case. That's not what this order says at all. But because the defense specifically picked out these officers, articulated why they needed it, and why there was a substantial need, and why they were material, the judge says, yeah, seems like the law in this state is pretty clear that they're entitled to this. While generally all personnel records of a current or former public official are exempt from disclosure under the Public Records Act, public disclosure of the personnel records sought here can be prevented by the issuance of a protective order stipulated to by the parties. Therefore, the court orders the following. The state shall provide to the defense the training records requested in request 160 of the motion to compel, unless the state demonstrates good cause for an extension of time. They have to be turned over by July 14th, which is in about 9 days. Further, the parties shall provide the court with a stipulation for a protective order and a proposed protective order for the training records. So it's not going to be something that's public. It's not going to be something that's leaked. It's not going to be something sprayed out there, but it is discoverable and it can be part of the case because the defense jumped through the particular hoops that they should have jumped through. There you go. I mean, I don't know how important it is, but I think it's the appropriate decision. It's kind of what we've said all along. All right, let's hit some of the super chats here. Susan, thank you for the super sticker. A lot of people sending in some nice congratulations super chats. So appreciated. Congratulations. P.S. I had my first pickleball lesson. Peggy, how did it go? What do you like? What's your favorite move? You got the forehand slice, top spin. You like dinking, serving. What's your move? Sweet tea. Has anyone seen the new Elantra video? Looks like a blurry car to me. I saw Mo also asked this question. Did you see the security cam video allegedly showing a white car around 4 a.m. that day? In my opinion, unless they can prove it's his car, it might not be enough identifying features to come in. What do you think? John, can you pull up this video? If you can pull up this video and add it to the bottom part of the stream so I can share it later. We'll take a look at it together, talk about what we think it proves, what we don't think it proves, if we can do this on the fly. John said he's on it, so we'll take a look at it in a little bit. Welcome to all the new members, Michael and Maddie and Mary Phillips and Kristen. All welcome to the crew here. Thank you, Elizabeth, on the congratulations. Unsolved Crime says, I send an email, let's spar. Okay. Maddie, Peter, here's to 250K and here's to 500K. That should be a mega pint next to the 500K, right? Oh, we got that one already. Unresolved Crimes. It's Joe McKinley. Congratulations. Been here over a year now. Only channel I've stuck with since then. And lawyer, you know, worth my top spot. Thanks, Peter and Papa Tragos. It's Joe McKinley. Thank you, Joe. Bodie, can't they do a deposition of the officers and ask them then about their training records? Yes. The issue is if you just ask in a deposition, but you don't actually have the training records, you can't impeach them. You don't know if what they're saying is true or false. And if they did something that's outside of their training, which we've literally seen in half the trials we've watched, right, Bodie? I know you've been around for a lot of them. If you don't know what the actual training procedures are, how do you know if what the officers are saying are according to their training procedures or not? That's why they need to get them maybe in this situation. We'll see how it's used. Azam, congratulations on surpassing another milestone, Peter. Keep up the amazing work. 500K next. So Peter Scissorhands. Yes, no, haha. I don't think we're going to do that. but we are still in discussions for what our celebratory video is going to be, and all of you will be taking part in that as well. Joy W. Could the Pennsylvania lawyer that handled BK's extradition be in trouble? He talked a lot about the case despite the gag order. I don't think so. He's not in Idaho. He's not under this judge's rule necessarily, but he also hasn't been saying as much since. So I don't think he's going to be in any real trouble, but maybe this will stop him from any further comment. We'll see. Okay, let's get to the meat of this video here. We're going to talk through the video of the Elantra whenever we get it, but these prior potential crimes of Bryan Kohberger. I am going to read here, and I'm not going to shout out the news place because I don't want to like people to be like, oh, they're so horrible, whatever. It's probably not the first one that comes to your mind, but it is a big one. 9 years before he was accused of this crime in Idaho, Bryan Kohberger was arrested in his native Pennsylvania and charged with misdemeanor theft for allegedly stealing his sister's iPhone. According to records reviewed by, I almost just read it. It was Kohberger's father, Michael, who reported the incident to police, according to the court records. According to records, Michael Kohberger told law enforcement Bryan had warned him not to do anything stupid after learning his son had taken the phone, adding that his son has struggled with drug addiction. Bryan Kohberger's earlier run-in with the law, as described in these records, is only now coming to light as he prepares to defend himself against the charges in Idaho. According to the records, Bryan Kohberger was 19 years old when he was arrested for the alleged theft in 2014. He served no jail time, according to officials. There is now no public record that the arrest or the outcome of the case. So this is how this is written, okay? So that's what they say. There's no record. And then they go to this. Monroe County, Pennsylvania offers first-time offenders the opportunity to enter into a pretrial program called Accelerated Rehabilitative Program or Disposition. Pretrial intervention, it's also known as deferred intervention, deferred prosecution. There's all sorts of different names. Almost every jurisdiction has this. We'll talk about that in a second. Martin Saudo Diaz, an attorney representing the Kohberger family, declined comment on the record describing the earlier arrest. The DA's office in Monroe County has had no comment. In a court filing Monday, Idaho prosecutors announced they are going to seek the death penalty against Bryan Kohberger. It remains to be seen whether the alleged incident in 2014. Hold on a second. That's fine, John. Just put it in there how you had it, and I'll play it small. That's fine. Just put it how you had it, and it's fine if it's small. I'll try to zoom in the best we can. It remains to be seen whether the alleged incident in 2014 and his previous alleged history with substance abuse will have any bearing or offer any clues in relation to what happened the early morning hours of November 13th, 2022. Okay? That is how that is written, that he definitely did this. His dad ratted him out, but now all the records of it are gone. And they're probably gone because there's this pretrial intervention program where, and most pretrial intervention programs, just to get behind the curtain, you have to admit that you did this, go through community service and classes and do all this stuff, and then they dismiss the charges at the end. Most places, I will say, I'm not positive about Pennsylvania, but it seems like it, the research that I've done, they're not automatically expunged. After PTI, many times those charges are dismissed. But that doesn't mean it just goes away from your record. A lot of people don't know. Just being arrested can stick on your record forever, even if it is a wrongful arrest that ends up getting dismissed. That can stick on your record literally forever unless you can get it expunged. So, just to be clear, this article and no reports are saying that Bryan Kohberger did, in fact, go through that program to get his charges expunged. They just put that back to back, so it made it seem like he went through that. Because there are a million other possibilities. Like number one, it didn't happen. And I'm not saying any of these are true, by the way. I'm just saying these are all the possibilities. A, it didn't happen. B, his dad was wrong or mistaken. C, there was no evidence, so his dad reported it. Maybe they brought him in, maybe they arrested him, but there was no evidence, so they got rid of it. Number three, they arrested him, did an investigation, found out they couldn't get enough to convict him, and they null-prossed it, as we say, or dismissed it or dropped the charges against him. His I've heard reports it was his sister's cell phone or some family member. Maybe they didn't want to prosecute. Victim didn't want to be involved. Maybe that's why they dropped it. But here's what we absolutely do know. In just about every state, including Pennsylvania, only certain things, and I'm going to say things, I'm not saying crimes or convictions for a reason, can get expunged. You cannot get what he's accused of here if you get convicted. You can't get that expunged, even if it's your first crime. You can only get arrests that did not turn into convictions, cases that were dismissed, not guilty verdicts sometimes, null process or when they drop the charges, wrongful arrests, or arrests for crimes that are so minuscule that they're lower level than misdemeanor or felonies. Those are the types of things you can get expunged. In some states, you can't even get DUIs expunged. So in order for something to even get expunged, which reports have been that this has been expunged, I don't even know that that's true. It has to be such a low-level crime or something that was a wrongful arrest or something that got dismissed that they could have never proven in order to get it expunged. So, if this is something that was expunged, the fact that it's getting out is obviously inappropriate. Somebody's leaking it. How annoying, how frustrating. More problems, poisoning potential jurors because now they're going to think he's a thief. Now they're going to think he's a drug addict, whatever it may be. Well, what's interesting about the process of getting something expunged is it is 100% appropriate and legal. If you are arrested and it goes away for whatever reason and then it gets expunged, you are allowed to tell employers that it doesn't exist. It's gone. Never been convicted. Never had any issues with any crimes because it's been expunged. It is gone. Now, certain employers on government levels, teachers sometimes, like law enforcement, they can still find it. But you can still become eligible for things that other people can't be eligible for if something has been expunged. Possess firearms, be able to hold public office, things like that. And in order to go through this process, it's not just like, it doesn't automatically happen, right? If I'm wrongfully arrested and everything goes away, that arrest does not just automatically get expunged. It's a process. It's an application process. Somebody's got to make a decision that this is correct. This fits into the expunction bucket. We are going to expunge this because that is just. That is the only fair thing. And by the way, sometimes I find myself having these discussions when somebody throws something at me about Kohberger as if I'm trying to argue that he's innocent, which I'm not. Well, he's innocent right now because he's presumed innocent. I have no idea if he did this. No idea. I don't feel confident putting my money down as to whether or not he did this. I think there's a lot of evidence. I think there's some holes. I think there's arguments on both sides. And I think we're going to see a lot more in trial and come out throughout the process because of the gag order. I think there's a lot we don't know. That's what I'm most confident in, that there's a lot we don't know. So I'm not arguing for his innocence or that he should go free or anything like that, besides the fact that he's presumed innocent, like I said. But this stuff just seems so unfair to me. How would you feel if somebody was bringing up something? Oh, here's another reason things get expunged sometimes and arrests like this go away. Law enforcement or the state attorney's office are like, this is a stupid kid making a stupid mistake. Or let's get him into rehab. He doesn't need to go to jail. Because sometimes those are the just decisions that law enforcement and state attorneys should make. And to the question at the bottom of this article, we'll see how this arrest and prior theft affects this case. Well, I'll tell you how it's going to affect the case. I'm pretty confident about this, especially if it's been expunged. It will not affect this case one bit. It will not be discussed at trial. It would not be discussed during the penalty phase if he was convicted. When you do score sheets, prior convictions and prior arrests, those can be something that can enhance penalties. This will not be one of those. If you get something expunged, it is not going to be held against you in the future. If you've been wrongfully arrested, if you've gone through the PTI program and those charges get dismissed, that is not something that's going to be held against you in the future. And again, just so we're clear, this is not being soft on crime and saying oh, this guy beat up an old lady outside of a Walmart and stole her purse. That guy's not going to go through PTI. This is for this situation. His parents turned him in because he stole his sister's cell phone. I don't know that that's what happened, but that would make more sense. A kid stole candy from a store, whatever. Those are the types of things that usually go through these programs. Those are the types of crimes that are usually expunged. And for the most part, and it seems like Pennsylvania says it can only happen if you've never been charged with another crime, never been arrested, not even convicted, but you can't even have any other arrests on your record to get something expunged. You can't steal things 5 times and on the 6th one get it expunged after you've already been convicted 4 times or arrested 5 times. And I think that that's important for us to think about and realize, instead of jumping to like, oh, he must have done this if he stole his sister's cell phone, to realizing those two have nothing to do with each other. My opinion, right? And I want to make sure that's clear. That is just my opinion. All right, let's get to a few more questions here. Belinda Caldwell. Hi, Peter. Did you hear that James Patterson has written a novel about the Idaho murders? No. Apparently, due out at the end of the summer. Do you know if it's true? A, I don't know if it's true. B, not a good, I don't think it's going to be a very good novel when all is said and done, because I think there's just way too much we don't know. Unless it's going to be about like the media attention on it or something. Regina Wright. Why do you think Brian hasn't given an alibi yet? I think he's just trying to gather as much information. I don't even know if he has an alibi, right? Seems like he does. Is it legit? I don't know. He's taking as much time as the court's giving him to get as much backup information as he possibly can. I don't blame him for that. Jory Johnson, congrats on 250K, friend. Don't forget to like. The hardest working guy out there, for real, for real. Where's his alibi? Didn't that time to produce come and go? What about changing those plates? So the changing of the plates, I think, just had to do with when he was moving. The alibi, I don't know if the judge says, hey, you're past the time for the alibi, you can't put it in. I'd be surprised if a judge did that if he had a legitimate alibi. But I think the court's giving him the time, it seems like, at this point. Eventually, if he has an alibi, my guess is he'll put somebody on notice of it because he has to. So we're still going to see. We'll see what we can find out about it. I'm not saying he has an alibi. Maybe he doesn't. But it doesn't seem like the judge has cracked down on him about it yet. All right, Rashenda, congratulations on 250K. Love your channel and your objective take on cases no matter what. Yeah, and I have to make clear sometimes, because people are like, oh, you must love this guy or you're a conspiracy theorist. No, not at all. I mean, like I've said from the jump, I'm betting money on guilty on the vast majority of criminal cases, because you play the numbers if you're going to bet, right? And the conviction percentages, especially on this high profile or this heinous of a crime, they go up even more. So I'm always going to bet on that. That doesn't mean I think he did it. And that doesn't mean I think we should treat him a certain way publicly while his case is being investigated. Those things can be true, right? CMC, congratulations on 250K. I'll have to see the rest on Replay Crew later. Well, good, CMC. We will see you back then. So, Nami, if cops knew the law, they'd be lawyers. So lawyers teach cops sometimes how to testify, how to have their depositions taken. I've worked with some cops before on that type of stuff, and they take law-related classes, and they do learn the law, but in a very different way than lawyers. Brianna and Kimmy are new members. Welcome, crew. Sav is not focusing. Best guess chance of trial this year, I'd put them at 25%. A 1 in 4 chance we get this trial this year. That would be my guess. All right. So let's see how we did here with this video. Okay. Oh, John, I guess you're going to have to play it, because I guess I can't play it. So go ahead and hit play. Now, this is not the right video, I don't think. Is it? Oh, this is the video? I was thinking of something else. All right, you guys can let me know if this is the video. This is not the video that I've been tagged on in Twitter. It's like more of a video from an apartment complex where you can see like a flash of something blurry drive in the background. See if you can find that one, John. If you go on our Twitter, it's there. So before we see it, I think that all of the discussion around some of these security videos Yeah, Mo said not the video. Um, I don't think it's overly helpful. I think law enforcement is going to be able to use it as another piece to the puzzle. We saw that it matches the description of the Elantra. We've seen so many times where witnesses will say stuff and we're like, I don't know, but they say it confidently. And a lot of times jurors are like, oh, yeah, that makes sense. That does look like the video. That does look like a white Elantra. At least you can say it's a white car. I don't know any Smallville fans out there. The red, blue blur. Remember when that's what they used to call him, the red, blue blur? Um, everybody's saying that's not the video. Yeah, I don't think that's the video either. So it's a pretty funny situation when you have imperfect, blurry videos that do match what you're trying to testify to, and it happens in every case, right? It happens in every case where you try to gain as much information as you can. And I got to be honest with you, if they had a video and it was a black car or a yellow car or a red car, maybe that would be significant. That doesn't match his car. They have something that looks like it's white. So at least it kind of fits in with what they're trying to prove. So I wouldn't be at all surprised if they use this video as part of their testimony and their case in chief. That wouldn't surprise me at all. Yeah, here it is. And I will say that. Let me see if I can pull it up here and find it for you guys. I'll try one other. Hold on a second. Let's see if we can get it. Just put it up there, John. Just put it up there, and I'll try to fast forward through it to see if we can get to the spot. It's not really that exciting, in my opinion, but we're near the end of the video anyway, so I'll try to put it up there before we bounce. Renee, do you think the state is being too aggressive with suggesting the death penalty? Could a Casey Anthony scenario happen where the jury feels the evidence is too circumstantial and they don't convict? So I think the answer is no, that the state is not being too aggressive. I think these are some of the worst crimes we've ever seen. I think that if he is convicted of them, he's absolutely, if your state has the death penalty, I think it is fit for a crime like this. And I think that the state is confident in their case. Could it backfire, like in the Casey Anthony situation, potentially? Yes, it could. And I think you're smart to kind of point that out, that could be, that should be something the state is weighing before making that decision, which I believe they did. Regina, isn't I was buying drugs a better alibi than no alibi in a quadruple homicide? If it were your client on trial, would you use that alibi? Just saying. If it was true and I felt like I could prove that, then yes. I do think I would. All right, John, I have it. So I'm going to share it now. So go ahead. You can pull yours out, and I am going to share this and see what we can get here. All right. So sorry, Regina. Yes, I would use that alibi if he told me it and he said it was true. I would absolutely use that alibi. Listen, the truth is what you work with, right? You can't make the truth what it is. Sometimes it's like, I've had clients committing lesser crimes when they were charged with something else. They're like, no, I wasn't even doing that. I was just, like you said, buying drugs or something. It's like, and you just deal with the consequence of that, especially if it's true. Oh, this is like all the footage, huh? Great. Anybody have a timestamp for this? It's like 4 a.m. or something. It's something around 4 a.m. It's in the description. All right. All right. So 405, 407, more headlights and a honk. All right. So let's go ahead. No, this is not right. Oh, okay. The time is at the top. All right, man. Riveting stuff here. I can't see the time. All right. So let's go to 405 is the first thing we see. All right. So here's the first thing we're going to see. Everybody keep an eye out for it in the next 7 seconds. Literally looks like a blur. Okay. That's not really helping me much personally. 407 is next. So we got 407.19. We will watch again here. You guys tell me if you see anything, all right? You guys tell me, and I'll look through the comments afterwards. So it's 407.19, 18.19. So I guess that's supposed to be headlights. Sorry, I forgot what it said already. So I assume they're going to like beef this up so we can actually see. So headlights of a white sedan. Okay, I couldn't really see that at 405. Then more headlights, and then more vehicle headlights at 409. So we can just kind of jump ahead a little. 409 here. And we can see the last thing here. It's better if you zoom in. You can see a white car, Heather said. I don't see anything. A bunch of people saying you missed it. You're going too fast. I'm not fast forwarding. This is just the normal speed. I'm also not slowing it down, so it could be that. Again, Peter, you missed it. His car allegedly was at 405.26. That's fine. You have to listen with headphones. Okay, I'm not going to really dive deep into this. This is not part of what we do here as much and trying to, zoom in and see. Okay, I saw more headlights there, I guess. So I think the point and the moral of that story is I think they're going to have to do stuff to make that useful. I don't think that's going to be obviously useful just on its own. Okay. Sam I am said the video isn't clear and you're not missing much. I get it. And other people are saying go back to the first one. That's a nothing burger. I get it. I apologize to people that are annoyed that I didn't go slow or zoom in. I think that there are a lot of channels that are doing that better than I am. Really diving deep into that type stuff. To me, the more you manipulate something, the more the defense will be able to pick it apart in cross-examination. And if I was the defense in this case, I would play it like that. I would say this is the actual video before the state did anything to it, before their experts got their hands on it. It just looks like a flash across the screen. I'd play it in regular time. They're going to slow it down. They're going to zoom in. They're going to enhance. They're going to try to show that it's a white car. Is it really going to be a white Elantra? Are you going to be able to make that out? To me, I mean, if I'm the defense, I'm going to use if this is something they're really relying on, they're really stretching. I don't think anybody's going to be able to say beyond a reasonable doubt that that's a 2013 white Elantra. Now, I think they're going to have other things to corroborate it, which is what I said in the jump. I think that it can be a small piece to the puzzle that they build on based on other recordings, based on the phone pinging, based on where the Elantra is, right? If they can match it up with that video at that time, I think it becomes a lot better evidence. So I don't think it's a total waste. I don't think it's a nothing burger at this point, but I don't think it's something huge. I don't think it's something huge. I just said, I don't think it's something huge that's really going to change things for the state. But in a case where you're building it on circumstantial evidence, every little thing can help, including that. And there are definitely some people in this chat right now, some people in this chat that do think it shows a white Elantra. It does show where it's moving. No, I wasn't trying. And again, I wasn't trying to demean anybody that does that. I wasn't trying to demean anybody that wants that. I like to prepare for the videos. I wasn't prepared for that. I didn't get to look at it enough. So people are saying I missed it, which I understand. I don't think it's overly helpful for me to explain that to you. I think we hit the things that I can be more help to you on. So that's what I always try to do. In case anybody's wondering why we do this. But I really appreciate everybody joining me again here. Hit that like button on your way out. Continue to let me know what you want to hear, what you want to see, any new Kohberger documents or things that come out. And don't feel bad if you have a question about something that's speculative or that you think is not relevant, but people are talking about. Ask me. If it's relevant, we'll talk about it. If it's not, we'll talk about why it's not. And try to keep people on the right track and in the right mindset so that even if potential jurors are seeing this stuff, they won't be poisoned. Just because you know about the case, just because you've seen something, doesn't mean you are disqualified at being a juror. And that's one of the parts that we're trying to do here with the media, is help out in that. You can see stuff, you can know stuff, and you won't be struck as a juror because you'll still be fair and unbiased. You'll still be presuming somebody innocent. All right. I appreciate you guys so much. Keep an eye out for the Corey Richins update. I thought it was pretty interesting. We learned some new things in this new lawsuit that was filed. Let me know what you guys think about that as well. And hit that reminder bell so you don't miss it. See you next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok @Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.